Being named an executor is a huge responsibility, often during a difficult time. But did you know that simple mistakes could make you personally liable for the estate's losses? This liability stems from not understanding one key law, Alberta's Estate Administration Act. This act doesn't just guide you, it sets the legal standard for your duties and protects the deceased's wishes. We'll break down what you must know about the EAA before probate, so you can act confidently and avoid costly errors. First, what is probate? It's the process where a court validates the will and officially gives you the authority to act. Is it always required? For most estates, yes. And if there is no will, probate is always necessary to appoint an administrator. So, what is your job under the EAA? It starts with a few core tasks. First, identify all assets and liabilities of the estate. Next, manage and protect those assets. Then, pay all debts, taxes, and funeral expenses. Finally, distribute the remaining assets to the beneficiaries exactly as the will dictates. You can't do any of this until the court gives you a grant of probate. It is the key that gives you legal control over the estate. You may have heard horror stories about probate fees. So why is Alberta's system considered unique in Canada? The reason is its fee structure. Unlike other provinces that charge a percentage, Alberta uses a simple tiered system. The fees are tiered, but here's the surprising part. They are capped. For any estate over $25,000, the fee is a flat $525. This means in Alberta, the challenge isn't the cost of probate, but correctly following the process outlined by the Act. Alberta is actively streamlining this process. The surrogate digital service for legal professionals shows a focus on efficiency. So you have the grant of probate. What are your immediate legal duties? This is where many executors make their first mistakes. One of your first jobs is acting as the deceased's financial representative. You must file a final T1 tax return for them. The EAA also demands a certain standard of conduct. You must act honestly with the diligence a prudent person would use. Let's look at a classic mistake: mishandling estate money. Putting estate funds into your personal bank account is a major breach. Another example is failing to protect assets. If an estate house is left uninsured and is damaged, you could be held responsible. So what happens if you fail in these duties? This is where we need to talk about the rights of the beneficiaries. The situation gets even more difficult if there's no will. Distribution is then strictly governed by Alberta's intestacy laws. These laws have very specific and sometimes surprising rules. For example, a blended family with a spouse and prior children. The spouse doesn't get everything. They receive a preferential share, the greater of $15,000 or half the estate. Not knowing this specific rule can lead to massive errors in distribution and legal challenges. You must know the law. And beneficiaries have power. They have the legal right to demand a full accounting and can challenge you in court for misconduct. Now let's connect the dots. Remember the risk of personal liability? That risk becomes real when a beneficiary challenges you. So, what makes Alberta's system unique? It's the combination of low fees and a highly defined legal framework on you. Think of it this way. The grant of probate is your license to drive the estate, but the Estate Administration Act is the manual. It's a system designed for clarity, not leniency. So how do you move forward successfully and protect yourself? The key takeaway is this. Understanding the Estate Administration Act is not just helpful, it is your primary shield. Following it protects two critical things: the wishes of the person who passed away, and you from personal financial liability. Before you act, read the will, find the EAA checklist online, and seriously consider getting professional legal advice. Managing an estate is never easy, but in Alberta, knowledge of the law transforms a challenging obligation into a clear process.